Hello everyone and welcome to Course 3, Employers' Responsibilities. My name is Danielle Bruard. I'm an employment lawyer from Walkers, and I'll be presenting this session today alongside my colleague Sarah Ash, also from Walkers, and Katie Bellingham from Focus HR. Today we're aiming to give you an overview of employers' responsibilities under the new discrimination ordinance. We're going to start with a summary of the key provisions in the ordinance, which for those of you who have attended Course 2 already will be a bit of a recap. Then we'll run through some issues that might arise during the employment life cycle and the employer's obligations in relation to them. We'll cover some specific exceptions that apply in the employment context, and then we'll have a section on bringing claims and remedies. So starting with some key provisions in the ordinance and with the protected grounds in particular. So in this table, we've set out on the left-hand side the protected grounds that we currently have under the sex discrimination ordinance, which are sex, maternity adoption leave, gender reassignment, and marital status. And on the right-hand side, we have the new protected grounds that will be coming into effect on the 1st of October 2023. Which are disability, carer status, race, religion or belief, and sexual orientation. There are also future phases of the legislation planned, but detailed proposals on those haven't yet been published. In particular, there's a proposal to add age into the new discrimination ordinance at a later date, and also to bring the existing grounds on the left-hand side of the slide within the scope of the new ordinance so that protection on all grounds is aligned. In the meantime, however, we'll continue to have the two pieces of discrimination legislation, the sex discrimination ordinance and the new prevention of discrimination ordinance. Moving on to a recap of the different types of discrimination and other prohibited conduct under the new ordinance, starting with direct discrimination. So that is where someone is treated less favourably because of a protected ground. And an example here in the employment context would be refusing to work with someone because they are Muslim, or say refusing to promote someone because of their race. Discrimination by association is where someone is treated less favourably, not because of a protected ground that they possess themselves, but because of a protected ground of someone they associate with. So an example of this in the employment context would be refusing to hire someone because they have a disabled family member, or because they are friends with someone who is gay, for example. Indirect discrimination is where the employer applies a provision, criterion, or practice, which is also known as a PCP, which puts those who share a protected ground at a particular disadvantage and which cannot be objectively justified. So an example might be requiring a role to be carried out full-time. That requirement for the role to be carried out full-time would be a PCP, and it may well put certain groups at a particular disadvantage. People who might find it harder to work full-time, for example, because of a disability or because they have caring responsibilities. In that situation, the employer would have to look at whether its requirement for the role to be carried out full-time can be objectively justified. If the role can be done on a part-time basis, or perhaps as part of a job share, without having a detrimental impact on the business or colleagues or clients, then it may well be indirectly discriminatory to require that role to be carried out full-time. Discrimination arising from disability is where someone is treated unfavourably because of something arising in consequence of their disability, where the treatment cannot be objectively justified. So an example might be a situation where someone doesn't gain a promotion that they have gone for because they have below average communication skills. If their below average communication skills arise out of a disability, then that will obviously be unfavourable treatment because of something arising in consequence of their disability. So then once again, the employer has to look at whether it can objectively justify its decision. If the role requires good communication skills, then obviously the employer should be able to justify its decision. But if the role does not, then the employer might be at risk of a claim for discrimination arising from disability. For anyone who would like further detail about the objective justification test, it's worth attending course 2 if you haven't already done so, because in that course we break down the constituent parts of these definitions and look at them in more detail. Moving on to other prohibited conduct. Harassment is unwanted conduct related to a protected ground or of a sexual nature, which has the purpose or the effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for them. So, for example, if someone was to make offensive comments about Jews, that may well amount to harassment. If someone was to make jokes in the workplace about a colleague being gay, again, that may amount to harassment. Now, it's important to note that that is the case, even if the colleague in question is not gay, or even if there are no Jewish people who have overheard the remark. And that is because the conduct needs to be related to a protected ground, but not necessarily a protected ground that the individual who is offended by it possesses. Harassment can also arise if someone is treated less favourably for either rejecting or submitting to harassment. So, for example, if a manager makes unwanted sexual advances towards a member of the team member rejects those advances, and then the team member is given less opportunities, employment opportunities than colleagues because of that rejection of the unwanted conduct, then that will equally amount to harassment. It's worth pausing here to note that harassment is not a claim under our sex discrimination ordinance. So this is something new coming in as part of the new discrimination ordinance. Finally, on this slide, we have victimisation, which is where someone's treated less favourably because they have complained of discrimination or given evidence in support of someone else's complaint. So an example here might be if someone raises a complaint of discrimination and then they are given a lower pay rise or no pay rise as a result of that, that would constitute victimisation. Moving on to the duty to make reasonable adjustments. This applies in 3 different scenarios. So where there is a provision, criterion or practice is the first scenario, or a physical feature, or a lack of an auxiliary aid, which puts a disabled person at a substantial disadvantage in comparison with people who are not disabled. And where one of those tests is met, what the employer must do is take reasonable steps to avoid the disadvantage or provide the auxiliary aid. So reasonable is obviously the key word here, and adjustments do not need to be made if to do so would create a disproportionate burden. So obviously the employer would need to weigh up all the circumstances, including factors such as cost and any impact that the adjustment might have on others, and decide whether or not it would be reasonable. Employers should consult with the relevant disabled person to get their views as to what adjustments might be required. And if a disabled person requests a specific adjustment, the employer should obviously consider that carefully and respond to them as to whether or not they can make it. Examples of potential adjustments in the employment context might be allowing someone to work flexibly. It might be providing specialist equipment, maybe specialist software or keyboard or chair, or it might be a change to the physical features of the premises. So it might be something like installing clearer signs around the building. Although it's important to note that to the extent that this duty requires changes to be made to physical features of premises, the duty will not come into effect until 1st of October 2028, so employers have a bit more lead-in time. I won't say more about the duty to make reasonable adjustments now, because we have a whole separate course on this duty, which is course 5, which I'd encourage you to sign up for to obtain more information about how this duty is likely to be applied in practice. And finally, equal pay and equal treatment. The ordinance states that where a person with a protected ground is employed to carry out the same or broadly similar work as someone who does not share that ground, they are entitled to be paid the same and receive the same terms and conditions, unless there is a non-discriminatory reason for the difference in pay or terms and conditions. So obviously there may be many reasons why people are paid different amounts, and it won't necessarily be a discriminatory reason. For example, there may have been different market forces at the time of recruitment, or the individuals may have different skills or experience. And where that's the case, it should be fine for the employer to pay them different amounts. The issue is only going to arise for the employer if the different amounts of pay are either directly discriminatory or due to indirectly discriminatory pay practices. When comparing themselves to another person, the employee can either compare themselves to another individual currently working at the company or to someone who used to work there within the last 3 years, which means that they can compare themselves to the predecessor who used to carry out their role, for example. They could also compare themselves to someone who's employed not by the same company, but by another company in the group. If someone feels they have a claim for equal pay or equal treatment, they need to bring that claim under this part of the ordinance and not as a claim for direct or indirect discrimination. And the relevance of that is that the remedy is different, as Sarah will come on to mention later. It's worth mentioning that there's no similar provision to this in our current sex discrimination ordinance. So unless and until we have phase 2 with the current protected grounds brought into the new ordinance, an individual would only be able to raise a claim for equal pay or equal treatment on the basis of the 5 new protected grounds. And finally, I just wanted to mention that these claims are different to the concept of equal pay for work of equal value, which is something that may come into force in future, but does not form part of this legislation. And finally, in this section, we just wanted to look at who the law protects. So unlike unfair dismissal, discrimination is a day one right. And so someone can complain of discrimination even if they've only just started employment or even if they haven't even started yet. So the ordinance will cover, for example, job applicants, current employees, former employees, and others such as apprentices, contract workers, partners in a partnership, and office holders. I'll now pass on to Katie.
Thank you, Danielle. Firstly, I'd like to start by stressing that nothing in the ordinance prevents an employer from hiring the best person for the job. This is a commonplace misunderstood element of equality legislation, and employers are often under the misconception that they must offer a job to an applicant with particular characteristics. This is not correct. It is unlawful for an employer to discriminate when deciding who to offer an employment, but the purpose of the legislation is to level the playing field, not create undue disadvantage. It is unlawful for an employer to discriminate when deciding who to give a role to and determining terms and conditions of employment. Clearly, the aim is to ensure that candidates with, for example, a disability are not excluded from a role on the basis of that disability, but the candidate must be capable of the given role, and employers should be ready to make reasonable adjustments to allow for the fair assessment of candidates. Think back to World War II fighter Douglas Bader. He was a double amputee who persuaded the RAF he could continue to carry on flying in the war. To do this, he had to prove that he was capable, and it is entirely reasonable to test capability with suitable adjustments. Discrimination in job advertisements was one of the primary areas the first forms of anti-discrimination legislation intended to prevent. Our ordinance follows suit and contains specific prohibition on discriminatory advertisements. We will all have seen advertisements in years gone by that indicate or suggest the intention to discriminate and make us question, is the true intention of the recruiter to get the best person for the job? Statements about somebody's gender, appearance, or their physical ability, where this is not relevant for the role, are unlawful. Careful consideration needs to be given on the language used and the requirements specified. As an example, it may be discriminatory to require a candidate from a certain country, but requiring a candidate can speak a certain language may be acceptable. Equally, you should not be stating that a candidate needs to be from Guernsey, but they do need to be able to obtain the right to live and work here. Remember, protection from discrimination applies even before anybody has actually applied for a job. Within the new legislation, the Employment and Equal Opportunities Service can serve a non-discrimination notice and impose a financial penalty for any contravention. So it's good to be ahead of the game and be really clear about what the role requirements are, not the person requirements. This is what you need to advertise for. Employers may be able to encourage applications from underrepresented groups, but more about this later. Requiring a candidate to have skills or attributes which are not essential to the role could be treated as indirect discrimination. For example, asking if a candidate holds a driving licence where it is not essential for the position could discriminate towards an individual who cannot obtain a driving licence because of their disability. When drafting job descriptions, consider what attributes are actually essential for any given role. This is not a person specification, but a well-considered list of what an individual needs to achieve and deliver. Any instructions made to a third-party recruiter should also meet this criteria. Employers must make reasonable adjustments to the interview process to avoid discrimination. The key point I would add is that employers can only make reasonable adjustments where they have been requested or where it could be said that they should reasonably have identified a specific need. Adjustments don't need to be onerous or expensive. Conduct an interview in an accessible room. Provide candidates with eyesight difficulties the role profile in a larger format, or give an individual with a disability more time to complete an assessment if they require. It is not necessary for the employer to keep stocks of documents in alternative formats, but you should be able to produce them quickly if needed. Unless the employer knew that the adjustment had been requested or that they were needed in any test of reasonableness, they will likely defend a claim of discrimination. Make it clear in your recruitment documents how adjustments can be requested and ensure staff involved in the recruitment process are well trained on your equality policy. Provisions of a reasonable adjustment for someone who needs it cannot constitute discrimination against an applicant that did not need the adjustment. Where medical questionnaires are necessary for the nature of the role, carry these out after selection and make the offer subject to satisfactory completion of recruitment formalities. If there are points identified that required further discussion, consider an occupational health report on likely capability given what has been disclosed. Applicants need only declare medical conditions which have an impact or potential impact on their ability to undertake the role. The best way to avoid issues around medical questionnaire is to ensure that the requirements for the given role are justifiable. For example, a role in aviation that requires a particular medical standard will qualify. The ideal model would be to have your questionnaires handled by someone other than the principal recruiter, unless there are points that need to be discussed. The aim here is to avoid discrimination and claims of it. You are not required to complete the recruitment of someone who is unlikely to be capable of fulfilling the essential functions of the role, but equally, an individual should not be prohibited from a role based on a medical condition that has no relevance to their performance of that role. Reasonable adjustments must always be considered before withdrawing an offer of employment. The collection of diversity monitoring information is acceptable, but I would encourage that diversity data is anonymous and kept separately from the main candidate application details. Do you really need to know who has declared something on a diversity monitoring form? This sounds like a data protection breach waiting to happen. So anonymise and amalgamate the data and do not keep information any longer than is necessary. Secondly, ask yourself, why are you collecting this data? How are you going to use the information? How are you going to store the data? And how will you communicate to applicants what is happening to their data and how it will be used? Diversity monitoring, where conducted, should inform policy and maybe even encourage positive action, but it should not drive target for recruitment of individuals ticking the boxes of a particular characteristic. This in itself may be discriminatory. The next video provides an overview of barrier-free recruitment.
You can certainly apply on the website at jlpjobs.com, which I believe is the John Lewis Partnership. And, you can apply for different roles, like in a group or on your own. But, of course, in my situation, it was a little bit different. And then, just trying to remember, there's tests that you can go through. So possibly because of the way I did it, I didn't necessarily go through many tests. So I did really well at the role playing, I think. And I was okay in the groups, but yeah, when I tried to help with this team building and building a tower, it didn't work. So that's kind of, there were two good elements, really. The remaining one was, we all said a little bit about ourselves, so that was fine. So it was, most of it was okay, but maybe that area let me down.
So before John even went through the recruitment process, because again, that can be quite daunting, and just to ensure that both ourselves and John were a good match and a good fit, we were wholly behind John doing work experience. So before anything is formal, we just had an informal chat, an informal meeting to talk about what the job entailed. And then once we'd done that, we set up some hours, and the hours that John did were the hours that that would fit around him, because it was work experience. And then we got John in different tasks, working on a till, doing some cleaning tasks, just to see again what job would suit John. He was a natural with the customers. So, and there's no doubt that John enjoys that interaction with customers, and they certainly take a shine to John as well. So that work experience was key before we went through any of the recruitment process, just to make sure that we weren't wasting John's time and ours. And he took to the actual tasks and job like a fish to water in that respect. And then we took him through the recruitment process.
I think it made it more comfortable because, when you're going somewhere new, it's bound to crop up sort of about previous work placements, and sometimes, it can be good for moving on to the current one because they can see what your strengths are, what your personality is. And sometimes things I haven't even thought of.
Most importantly, when it came to the interview process, John was allowed to have someone sit in with him. And again, that wasn't so that John, they would do the answer the questions for John. It was more to give him the confidence of having someone in the room. so that, like I say, he felt more confident, and just as a nod to have someone there with him, so it just wasn't me and him in the room. And also we did it one-to-one, so the group interview can sometimes be quite daunting for people, and it just meant that he didn't have that pressure of having other people around him, because we do find that some people in that situation, they can't shine if they've got other people in the room. But if you do a one-to-one, it gives them the opportunity of just being them in the room, and they can answer those questions and not have other people around them that might shine more than them. So John was answering all the questions. I would put the questions in maybe a different way for John, but the actual answers we were expecting would be the same as anybody else. So there's no favouritism. There's no sense that John's getting something that somebody else wouldn't.
I'm now going to move on and cover genuine occupational requirements. In some circumstances, an employer can require a role to be carried out by a person with a particular ground. However, the employer would need to be able to justify this. So, for example, a charity that supports people with visual impairments may wish to seek to recruit an outreach worker who currently has or previously has had a substantial visual impairment. They consider this crucial to the job because they feel that the needs of their clients can only be met by an outreach worker who has shared their lived experience. So in this example, the charity would be able to justify the need for this. Another example might be if an employer advertised for a female care worker, and that's because of the fact that the care worker would be required to carry out intimate care tasks for other women. So it may well be a genuine occupational requirement for the carer to be female in this circumstance. So what can't you ask in a recruitment situation? So employers should not be asking for information about protected grounds during a recruitment process, which indicates or might reasonably be understood as indicating an intention to do anything prohibited by the ordinance. So asking for such information could lead to inferences of discrimination and/or to the imposition of a non-discrimination notice. So, for example, it's not advisable to ask general questions about someone's health, sickness record, or childcare arrangements. In addition, it's quite uncommon now, and there would be no requirement why a candidate would need to attach a photo for an application, so it's not advisable to ask for one. Employers need to think really carefully about what functions are essential for a role and draft job descriptions accordingly. And I would expect many employers will already be mindful of this, but given decisions or actions taken pre-employment during the recruitment process are already covered by the Sex Discrimination Ordinance and will be covered by the new ordinance, it's very important to mitigate your legal risks, and that employers look carefully at their recruitment processes and consider upskilling those involved in interviewing and recruiting candidates. What can you ask? So employers can ask about protected grounds if they have a legitimate reason. So, for example, checking a person's employment permit or immigration status. Employers obviously still need to comply with our population management and immigration laws, so it's entirely reasonable to check for these things. In addition, checking whether the employer is under a duty to make reasonable adjustments in relation to the recruitment process. So you shouldn't be asking, are you disabled? But you could ask, would you need any support to carry out any part of the job? And if so, what support might you require? And when it comes to reasonable adjustments, we'll be covering this in much more detail in session 5. We have a whole session dedicated to reasonable adjustments and accessibility. In addition, it's obviously absolutely fine to ask questions which are designed to determine if the applicant can undertake any or all of the essential functions of the job. And that can include questions about whether they may need any adjustments or aids in order to carry out these functions. So again, as I mentioned, think about what functions are essential and draft your job description and tailor your interview processes accordingly. So what happens if you find out that the candidate you're interviewing has alleged discrimination against a previous employer? If you learn that an employee has made allegations of discrimination against a previous employer, is it discriminatory to refuse to hire them? Well, yes. If the reason you're refusing to hire the candidate is because of the previous allegations, and those allegations were raised in good faith, this would likely constitute unlawful victimisation. And we'll come on and talk more about victimisation as a head of claim later in the session. It's really important to remember that someone may have brought an entirely legitimate claim previously, and this may have been their only option. This does not automatically equate them to being a troublemaker or a serial litigant. We live in a small jurisdiction and claims are in the public domain, so there are reputation issues here. However, relying on hearsay or making a judgment because someone has brought a claim which leads to the withdrawal of an offer will be victimisation, and this could lead to a claim being brought against you under the ordinance, and we'll come on to talk about remedies in more detail later. Moving on now to positive action. This is an exception which we'll talk about, and we'll talk more about these later, and it applies to the new protected grounds coming in phase 1. So positive action, employers are entitled to take action with the aim of ensuring greater equality on any protected ground. So what does that mean in practice? So employers can try to attract applicants from underrepresented groups through, for example, targeted recruitment events or guaranteed interview schemes. So, for example, if you were an employer who had signed up to GET's Employers Charter, this would show a commitment to offer guaranteed interviews for disabled candidates who meet the role requirements. Employers can consider diversity when recruiting, but this must only be a determinating factor if everything else is equal. So where you have two candidates that are equally qualified and could both do the job, you may choose as an employer to pick the candidate from an underrepresented group in your organisation. However, employers must not set quotas or automatically prefer someone because they are from an underrepresented group. Again, it is all around if everything else is equal. Moving on now to offers of employment. So bear in mind the equal pay and equal treatment rules that Danielle referred to earlier. It's really important to ensure that differences in pay and benefits can be justified and are not tainted by discrimination. So understanding that market factors, particularly in a competitive recruitment market, may lead to salaries being inflated, and that's required to secure people. That's understood. However, employers should then be looking at pay disparities in the workforce and addressing these through pay reviews and over a period of time to ensure that those disparities even out. Employers should ensure that any decision not to offer pro rata benefits to part-time employers can be objectively justified. Otherwise, the risk here is that it could amount to indirect discrimination on the grounds of disability, carer status, and/or sex. So, for example, it's normal practice to prorate holidays and pension, which is linked to salary, but it does become more difficult with decisions regarding things like private medical, dental benefits or travel. Benefits can be age linked, and that's normal practice currently. We've also seen flexible benefit packages becoming more popular, where employees get the option to select which benefits matter most to them. Of course, this is already an existing risk under the Sex Discrimination Ordinance, but will extend to other protected grounds when our new legislation comes into force. Employers should also consider requests for flexible working. Now, employees in Guernsey do not have a statutory right to request flexible working like they have in Jersey and in Great Britain. However, it's good practice that employers in Guernsey would consider these, because refusing a request to work flexibly without good reason could constitute indirect discrimination if the reason for needing to work flexibly is linked to a protected ground, for example, carer status, disability, or perhaps even religion. So employers must be able to justify any refusal, for example, based on the demands of the business or the impact on customers or colleagues. So it's really a case of considering those requests carefully and determining whether or not they're going to work for your business. And cost alone is unlikely to be enough of a factor to reject a request for flexible working. I'm now going to hand back over to Katie, who's going to cover some of the other issues that may arise during employment that employers need to be aware of.
Equal opportunities describes the broad nature of anti-discrimination provisions in the workplace. It includes opportunities for promotion, regrading, transfer or training, or in relation to benefits, for example. In my own working career, thankfully many years ago, I have worked with individuals who had unwritten rules to avoid the recruitment or promotion of young females, the assumption being that they would later leave to have children. This is illustrative of the subtle ways in which discrimination arises. Employers cannot prohibit employees from talking to colleagues about their pay, where the discussion is in the interest of identifying if a claim under the legislation may exist. Contractual clauses prohibiting discussion of pay and reward are commonplace, and these may be held to be unenforceable under this legislation, so it would be wise to update your documents sooner rather than later in this regard. What happens when an existing employee develops a disability which impacts them at work? This slide provides clear guidelines, yet is an area where employers in Great Britain, where similar legislation has been in place for many years, still get confused. The key questions to ask are: could the issue classify as a disability? What additional support, if any, is required? Are there adjustments that should be offered? Should further medical advice be commissioned? If so, what precise advice is needed? Fundamentally, the question about ongoing capability and capability if adjustments are made must be addressed. Decisions can then be made about how reasonable it is to expect the employer to make reasonable adjustments to support continued employment. Reasonableness is one of the most challenging concepts for employers to navigate. There is a lot of interesting case law in other jurisdictions that we can learn lessons from. As an example, Holland and Barrett in the UK were held not to have considered reasonable adjustments properly when they failed to consider employing a second member of staff on a shift where a shop manager had a condition requiring more frequent toilet breaks. In cases such as this, it's necessary to consider both the reasonableness of the request and the reasonableness of the response. It will be possible to learn more about reasonable adjustments in session 5. The next video talks about supporting existing employees.
So I would come back for half a day, building up to a half day a week, coming back to 2 or 3, 4 half days a week. Then it would be 1 or 2 days a week. And eventually, I think within about 12 months, I was back 5 days a week. It also allowed me to stop if I felt things were getting too much. So there was an acceptance. I can't do any more today. I need to go. It also meant that my physical recovery then improved, because what the employer also allowed me to do was take that time out to go and continue with occupational therapy and physiotherapy, which was so important to my physical recovery, which then helped my mental recovery. Eventually, after a few 2 or 3 years, I was able to rejoin the board as a director of the company again. Not as managing director, because that is a role that I personally didn't want to fulfil, and it wouldn't have been right at the time. But it was ultimately the ability of the employer to recognise that this was going to be a gradual process, but have faith that there would be a recovery, and to listen to the individual, the employee, about the pace of that recovery and what it actually really meant, what it really looked like. Then when it came to the sort of the fatigue, one of the things that surprised me, that no one I don't think really understands how to go through it, is that a lot of noise, and I don't just mean the noise of an office, all the clattering, sharp noises can really affect you. But the noise of bright lighting, lots of information, can actually overwhelm mentally and cause all sorts of issues there and then, which mean you can't function. So in a working environment where you've only been in a hospital and then home, and then you're moving to a working environment, it's quite important for an employer to provide a quiet space to allow you to readjust. And you might need that for 6 to 12 months. But that was provided for me, and that was a very useful, simple thing to do.
In my world as an HR advisor, it goes without saying that applying policies fairly and consistently can help avoid discrimination. Employers must not treat one employee less favourably than another. When following disciplinary or capability procedures, be alert to the fact that performance and conduct could be impacted by disability or caring responsibility. Failing to take account of this could lead to claim of indirect or direct discrimination, or a claim that you have failed to make reasonable adjustments. As an example, an employee has started coming into work late, missing their start time, and arriving disorganised and clearly flustered. Their line managers considered this to be a conduct issue and wants to move straight to a disciplinary process. In discussions with the employee, it becomes clear that their morning routine has become increasingly hectic as they assist their elderly parent who suffers with dementia with their morning routine and taking of medication. Proceeding with the disciplinary in this instance could constitute indirect discrimination if the employer does not approach the issue in a proportionate way. If the role allows, consider a later start date or a reduction of hours that would ensure the individual is able to make it in for their start time and relieve some of the pressure they may be feeling and any suggestion of underperformance, rather than taking disciplinary action. Discrimination can be subtle, refusing annual leave where that person needs time off to care for a disabled relative, following treatment, for example. When looking at other areas where discrimination can arise, there is a mountain of case law on dress code and uniform requirements. Claims may arise when an employer prohibits religious symbols or requires stricter dress code for one sex or another. Ultimately, it is open to employers to specify a dress code so long as it is reasonably justifiable and requests for variation are given due consideration. Brand reputation and operating environments are likely to be considered. The requirements to provide food options of various kind is a matter of respect as much as good practice, but may also now be a point of law where they are required for dietary, medical or religious reasons. Care should also be taken where alcohol is provided and there is an expectation of consumption.
Thanks, Katie. So next, I just wanted to mention a couple of points in relation to managing sickness absence and sick pay. The first point is that it can be helpful to record disability-related absence separately to other absence. And the reason for this is that it can sometimes be a reasonable adjustment to adjust the trigger points in your sickness absence policy for someone who is disabled, or to discount disability related absence if you're going through a redundancy selection process. Now, that's not to say that any disability related absence must be tolerated by employers. If the level of sickness absence becomes incompatible with someone continuing to carry out a role and the employer feels they need to terminate, the ordinance does allow them to do that. And Sarah will come on to talk about termination in a minute. Allowing time off for medical appointments or to receive treatment may also be a reasonable adjustment. But as you might expect, it's going to depend on the frequency of the absence and the impact on the business. Very occasional absence would probably be a reasonable adjustment to tolerate that. But if someone needs a lot of time off, that might be less likely to be reasonable. Then finally on this slide, one thing employers must remember when processing health information is that they need to comply with their duties under data protection legislation too. So they must only use health data that they've collected for the purpose that they've collected it for. And they must not share it more widely within the organisation than they need to, for example. In relation to sick pay, you sometimes find that employers' sick pay schemes have a discretionary element where the employer can determine whether to continue paying sick pay after a certain point. Now, if you have that kind of scheme, you just need to be careful to ensure that you're not discriminating against those with particular disabilities when deciding how much sick pay to give. For example, if you found that you were generally extending sick pay when somebody had a physical ailment, but not when they had a mental illness, for example, that may well constitute discrimination. In Great Britain, where they have very similar legislation in this area, employees have sometimes tried to argue that it would be a reasonable adjustment to extend sick pay beyond the employer's usual boundaries. Now, the courts over there have held that that won't usually be a reasonable adjustment. So that's not something we expect that you would need to do, unless perhaps it is the employer's delay in implementing reasonable adjustments that has meant that the person hasn't been able to return to work sooner. What should employers do if they become aware of allegations of discrimination? They should investigate the allegation promptly and thoroughly, and in line with any internal procedures that they may have. I imagine that most larger or medium-sized businesses already have an internal grievance procedure, which they should use in these circumstances. If you don't have such a procedure, it's worth looking at the Employer Relations Guide on raising and handling grievances, which sets out the main steps that you would need to follow. What about victims who don't want to raise a formal complaint? You sometimes do find that individuals will mention allegations of discrimination but don't want to take those forward. It can be advisable for employers to still look into that allegation anyway, because if you don't investigate it and then the alleged perpetrator goes on to discriminate against or harass someone else, you might find yourself facing a claim that could have been avoided if you'd looked into the allegations when they were originally raised. Also, if you don't deal with allegations the first time they're raised, it will be much more difficult to rely on the employer's defence that we'll come on to cover in a bit, that you took all reasonable steps to prevent discrimination from occurring. It's also important not to victimise anyone who has raised a complaint or provided evidence in support of a complaint, and your grievance procedures should make this clear. I'll now pass on to Sarah to run through some issues to bear in mind when you are considering terminating an employee.
Moving on now to avoiding discrimination. Employers should ensure that individuals with different protected grounds are treated equally by applying processes fairly and consistently. We've talked about how helpful it is to have policies and procedures, and one real advantage of this is to make sure that you have a framework to follow in each different scenario. Employers should also ensure criteria used in a redundancy situation are not indirectly discriminatory. So, for example, absence could be indirectly discriminatory, and it may be advisable to discount disability-related absence in some circumstances. In addition, flexibility in terms of willingness to work unsociable hours could be indirectly discriminatory on the grounds of disability, carer status, or sex. So employers should take care when considering what appropriate redundancy selection criteria they might be using. I think it's important to remember that employers do not need to continue to employ someone who cannot fulfil the essential functions of the job. Capability is a fair reason for dismissal. However, it's very important that a fair process and procedure is carried out in order to mitigate any legal risk. However, if the individual is disabled, employers should consider the following questions prior to termination. Have we made all reasonable adjustments? Are there other reasonable adjustments that could be made and should be considered? Is the reason for dismissal connected to the employee's disability? If so, is dismissing the employee at this stage proportionate, or should the employee be afforded a longer period of time to see whether or not they can fulfil the functions of the role, perhaps with additional reasonable adjustments? Can we redeploy the employee somewhere else in the business? Is there another role that might be better suited, for example? Is the employee eligible for permanent health insurance or ill health early retirement? Those are important considerations to consider. Have we followed a fair termination process, including consulting with the employee, and particularly important over consulting in terms of reasonable adjustments and whether or not those have been made, or if the employee has other suggestions that might assist. Employers should also consider medical evidence and potentially taking occupational health reports as a way to explore the situation further. We also come on, and we've mentioned before, our session 5 on reasonable adjustments and accessibility. So we will go into this in greater detail in that session. So turning now to post-termination. Employers must be careful not to discriminate against former employees, and this most often comes up in relation to references. Now, most formal references are brief and simply give dates of employment and the roles performed, but it's very important that those who might be approached for references are aware of what detail within the reference is to be given. Employers must not give a poor reference in retribution for the employee having made allegations of discrimination, for example. People need to be very careful and mindful about any post-termination conversations that they have with somebody else about a particular individual that may have worked within their organisation. Essentially, keep to the brief and be careful about what's said. Otherwise, it does carry a post-termination risk for employers. So I'm now going to move on and talk about some exceptions. Now, in addition to the general exceptions that we covered in session 2 and others that we've already covered, so genuine occupational requirements and positive action, which I spoke about earlier in the session today, the ordinance also contains the following exceptions. So, for example, where employment is for the purposes of organised religion or relates to a senior leadership position in a school with a religious ethos, preference may be given based on religion. So, for example, a Catholic school can give preference to a Catholic candidate when selecting a new head teacher, for example. There's also no requirement to recruit or retain someone if the employer reasonably believes that they have committed or have a tendency to commit acts which constitute a criminal offence punishable by imprisonment. So, for example, this may apply where a person has a disability which results in a tendency towards acts of physical or sexual abuse or viewing of indecent images. You could likely justify not hiring or terminating someone for these reasons anyway under the objective justification provisions, but this specific exception means that you don't even have to go down that route. It is not discriminatory to grant an employee's request for flexible working, provide benefits only for employees with caring responsibilities, or provide benefits to employees for family situations. So, for example, company maternity pay, and someone cannot complain that failure to offer some benefits to the same benefits to them is discriminatory. In addition, the requirement to hold certain qualifications in order to carry out a role or undertake vocational training is permissible where this is reasonably necessary and the requirement applies to everyone. So, for example, if a role requires a UK or Guernsey-based qualification, requiring candidates to have this qualification will not be discriminatory, even though individuals not from the UK or Guernsey are less likely to hold that qualification. If, however, it is not reasonably necessary to hold that precise qualification and a foreign equivalent would be okay, employers should accept this alternative. And finally on the slide, Grow Limited, GET, with the Guernsey Employment Trust, and similar organisations can treat those with particular disabilities more favourably than others when undertaking their activities. I'm now going to move on and look at some remedies. So as you can see from this slide here, we've set out what the process might look like if a complaint is raised. Now, although there's no initial notification required in the employment context, in practice, employees will usually raise concerns under the applicable internal company process, likely to be a grievance process, for example, before they would contact EEOS. And this should be encouraged as an early means to resolve potential complaints before they become more formal. If a complaint is not resolved, then the next stage would be to notify the Employment and Equal Opportunities Service at this time. And at that point, there may be an opportunity to seek to try and resolve the complaint. If both parties agree, there may be the possibility to then engage in pre-claim conciliation, which of course may resolve the complaint before it needing to go near the Employment and Discrimination Tribunal and to end the process. However, if a complaint is not resolved, then a formal complaint would be made to the Employment and Discrimination Tribunal. And of course, at that point, there are a number of things that may happen. The claim could proceed all the way through the tribunal to a hearing, but there are a number of ways that it could end sooner, for example, through the claim being struck out or settled through post-complaint conciliation. So if someone were to bring a claim, as we've said, the first step would normally be to raise the issue internally under the employer's grievance process. But if this does not resolve the issue and the individual wants to bring a claim, they must first notify the new Employment and Equal Opportunities Service, who will offer that pre-claim conciliation. And as I've said, it's important that both parties need to be prepared to engage in that conciliation process for that process to take place. If the parties do not want to engage in pre-claim conciliation or pre-claim conciliation is unsuccessful, the individual can then move on to bring a claim. Now, employees normally have 3 months to bring a claim from the act complained of, although the tribunal has some discretion to extend time. If the parties choose to engage in conciliation, this will pause the time limit for bringing a claim to essentially allow, and in the hope that that conciliation will lead to a resolution and end the process. But if not, that then the individual has not lost out on the opportunity to then proceed to the next stage by attempting to resolve the issue. The tribunal process will be similar to the current process that we already have, but we are going to see the introduction of new tribunal rules and procedure, which will formalise the process a little further. When we're looking at remedies, this is one area where we're seeing a change from the current remedies and awards that are currently set out under the Sex Discrimination Ordinance. And these remedies that I've set out here on the slide will apply to that piece of legislation and our new ordinance. So as you can see, on the first line of the slide, if one complaint is raised under the ordinance other than equal pay, the compensation that may be recovered if that claim is successful is up to 6 months' pay, plus up to £10,000 for injury to feelings, hurt or distress. This is different. Our current limit under the Sex Discrimination Ordinance for compensation is a sum equal to 3 months' pay. Now here, as you can see, the wording is different. It's up to 6 months' pay. So suggesting that there will be some discretion for the tribunal in terms of the level of award that may be given. Moving on, if 2 or more complaints under the ordinance are brought, excluding a claim for victimisation, and if these complaints are brought on the same facts, the compensation cap rises here, and it could be up to 9 months' pay, plus up to £10,000 for injury to feelings, hurt or distress. If 1 or more complaint under the ordinance, plus 1 or more complaint under the Sex Discrimination Ordinance, again excluding victimisation, the compensation here will be up to 9 months' pay, plus up to £10,000 for injury to feelings, hurt or distress. If 1 or more complaint for discrimination, excluding victimisation, but including unfair dismissal is brought, again, it's the same cap of up to 9 months' pay, plus up to £10,000 for injury to feelings, hurt or distress. And as you can see, victimisation will be dealt with as a separate head of claim. And here, if successful, somebody could be awarded up to 6 months' pay, plus up to £10,000 for injury to feelings, hurt or distress. The fact that this is a separate claim means that this could be brought alongside 1 or more complaints under the ordinance at the same time, and it will be dealt with separately by the tribunal when it comes to the compensation awarded. And finally, moving on to equal pay. As you can see from the slide, this is up to 6 years back pay, but it's important to note that this will only come into effect from when the ordinance comes into force. So equal pay awards can only go back to the time when the ordinance came into effect. So you would look back up to 6 years from when the claim was lodged. Moving on now, I'm going to come on to talk a little bit more detail about injury to feelings, because as you can see from this slide, it's relevant in a number of these different claims. So injury to feelings, this is an award to compensate for the effects that the discriminatory act has had on the particular claimant, and the size of the award will take into account factors such as the degree of hurt, distress or upset caused, the seriousness of the treatment, and whether the discrimination was a one-off incident or a course of conduct. However, it's important to note that if there is a very serious one-off incident, that could result in the highest band or level of award being given by the tribunal. Now, as you can see from the slide, I've set out the different bands, lower, middle and upper. Now, these are yet to be affirmed by the states, but the Committee for Employment and Social Security intends to recommend these 3 bands. And as you can see, the lower band, £500 to £3,000, the middle £3,000 to £6,000, and the upper £6,000 to £10,000. So when the tribunal is considering an award for injury to feelings, it will consider where it feels appropriate that that award is placed in which of the bands. And these amounts will be set in regulations, which we obviously have yet to see at this time. Finally, just a quick note that injury to feelings may become very important in non-work related cases. Now, obviously, today we're focusing on employers' responsibilities, but if you are an employer but also a service provider, for example, injury to feelings is an award that may be given in a non-work related cases. And just a flag that we'll be going into this in more detail in session 4 in our service providers' responsibilities. So you may wish to sign up to that session if you haven't already. I'm now going to hand over to Danielle.
Individuals who are found to have discriminated against or harassed their colleagues can be found personally liable for discrimination under the ordinance. But often the employer will also be liable for those acts of discrimination. And that's because anything done by an employee in the course of their employment is generally treated as having also been done by the employer. And that's regardless of whether the acts were done with the employer's knowledge or consent. However, there is a defence available to employers if they can show that they took all reasonable steps to prevent the employee from doing the discriminatory act. So when will employers be able to rely on that defence? Well, case law from Great Britain, where they have the same defence, shows that an employer would generally have to have a policy in place which clearly sets out their expectations in relation to equal opportunities and anti-harassment. They need to have made all employees aware of the policy and the implications of breaching it. They should train their managers and supervisors in equal opportunities and harassment issues and take steps to deal effectively with any complaints that are raised. For an example of a case from Great Britain where the employer tried to rely on this defence and failed, it's interesting to look at the case of Allais and Galen. And in that case, the employer tried to say they'd taken all reasonable steps to prevent one employee from racially harassing another, but the tribunal disagreed. They found that although the employer had carried out training for employees on equal opportunities matters, that training had been carried out more than 2 years before the incidents in question, and it was therefore described as stale. The fact that the employee who had harassed their colleague thought that their comments were just banter, and people who they complained to, managers who'd also undergone the training, took no further action, was seen as further evidence that the training that had taken place was insufficient and out of date. It's also important to bear in mind that employers can sometimes be liable for employees' acts, even if they're carried out outside of work time. So, for example, at work social occasions, or even if they're off the premises at the time. In some cases, employers can also be liable for the acts of third-party agents. So that might be contractors, consultants, agency workers, for example. And there's a separate offence of causing, instructing or inducing a third party to contravene the ordinance. So, for example, if a cleaning company had a number of corporate clients and one of the clients asked the cleaning company not to send any foreign workers, not to assign any foreign workers to their account, that would be an example of instructing a third party to contravene the ordinance. And I gave the example of corporate clients because the ordinance does not, of course, determine who you can engage in a personal capacity as a cleaner in your own home, for example. So finally, what can employers do to prepare for the introduction of the new ordinance? Well, they should familiarise themselves with the new duties, which is what you're obviously here doing today. But as well as attending the training, it's worth reading the guidance notes that are going to be published. They're not available yet, but they will be available before the ordinance comes into force, and will set out further guidance on some of the main provisions. It's also important to raise awareness amongst the workforce and to consider organising training for employees and managers. And that might be sending additional employees or managers along to the future consortium training sessions, or it might be arranging some more bespoke in-house training. We're sometimes finding that employers are deciding to run separate sessions for the wider employee population to the sessions they're running for managers, due to the different things that those different groups are going to have to bear in mind. It's also important to ensure that any training is carried out relatively regularly to capture any new joiners. Employers should review their recruitment documentation, for example, to ensure that they are asking candidates about the need for reasonable adjustments when attending interviews, and also to ensure that managers are aware what they should and should not be asking at those interviews. Employers should review their current employment policies, in particular to ensure that the policies couldn't be deemed to be indirectly discriminatory in any way, and should consider introducing new policies if they don't already have a policy that deals with equal opportunities and harassment. It's a good idea to carry out an audit of pay and conditions just to ensure that any differential in pay or terms and conditions isn't due to any direct or indirect discriminatory factors. And then finally, if your organisation is looking for ways to promote opportunities for underrepresented groups, it's worth contacting organisations such as Guernsey Employment Trust, Equality Guernsey, or Guernsey Mind, who would be happy to provide further support.